1 minute you have to. It's 1 second.
मैं तो अपना शॉप
उधर फिर बच्चे सामने हैं ना, आप इधर आओ। तो मैं आपको 3 माइक आपका बंद हो गया भाई।
Honorable Judges of the Supreme Court of India, Honorable Law Minister, Learned Attorney General, respected seniors, dear colleagues, I welcome all of you on this wonderful evening, colorful evening, Learned Attorney General. Respected seniors, dear colleagues, I welcome all of you on this wonderful evening, colorful evening, on a day which is extremely important for each one of us. May I request our President Sir and Vice President Sir to kindly accompany our Chief Guest, Chief Justice of India and Honorable Law Minister to light the lamps. I request all members to kindly rise for Vande Mataram.
बलदेव सर
May I now invite the opening batsman of... I request President Sir, Vice President Sir to kindly accompany Honorable Chief Justice of India, Honorable Law Minister, Attorney General Sir on the dais, please. May I now invite the opening batsman of the SCBA team on the cricket ground as well as on the SCBA functions, V. Shekhar Sir, our Vice President Sir, to please welcome the dignitaries and all of you.
Thank you, Aishwarya. Good evening to all. Respected Honorable the Chief Justice, the other Honorable Judges, the Honorable Law Minister, the Attorney General of India, the other law officers, Mr. Dushyant Dave, our beloved President, Mrs. Aishwarya Bhati, Honorary Secretary, the office bearers, and other executive committee members, members of the SCBA, Mr. P.P. Rao, Mr. P.H. Parekh, Mr. M.N. Krishnamani, the past presidents, Mr. Shivaji Jadhav, President, Supreme Court Advocate and Record Association, Mr. Suryakant, Vice President, Mr. Vipin Nair, Secretary, friends from the electronic and print media, the Secretary General, and others from the Supreme Court Registry, the staff of the SCBA, ladies and gentlemen. It gives me a great pleasure in welcoming you all on the occasion of celebration of Law Day today. We have assembled here today to celebrate the anniversary of momentous event in the history of our nation, that is the anniversary of the adoption of our Constitution, the day on which our founding fathers subscribed to this document by signing the same and thereby unfolding the philosophy, social, economic and political for the governance of free India. We have every reason to be proud of and to celebrate this unique occasion. We take this opportunity to thank the founding fathers for this document, who spent a good deal of their time and energy in giving shape and guide the future destiny of the country. The Supreme Court Bar Association in 1979, under the vibrant leadership of late Dr. L.M. Singhvi, the then president of SCBA, selected 26 November to commemorate this day as Law Day, as it is on this day the people of India gave to themselves the exclusive manuscript to govern them, that is the Constitution of India. This document was delightfully designed to make this country a democratic republic to be governed by rule of law and to continue it as one huge nation with its astonishing and matchless unity and diversity. The real purpose of celebrating Law Day is to rededicate ourselves to the cardinal principle which form the solid foundation on which this grand constitutional edifice is erected. Rule of law, independence of judiciary, independence of the legal profession. These three principles are intimately interconnected. The focal purpose of an independent judiciary and an independent bar is only to ensure that there is a rule of law. The main endeavor of celebrating Law Day is to make sure and to offer ourselves to the rule of law. Consciousness about rights has grown while correspondingly executive dispensation of justice has been reduced. As a consequence of this, litigation has multiplied. The common law rule that every wrong has a remedy has led the litigants to approach the courts. Perhaps a little careful scrutiny in the lawyer's chamber would keep away some litigation from the court. The influx has been so huge almost in every court throughout the country that the backlog has been presenting a difficult and challenging problem to the judiciary to negotiate with. We believe in system of governance which is by the people and for the people, and when we speak of a welfare state, we mean by a well-informed citizenry where every decision of elected government should be in consonance with public trust. It is very important that today's citizen should be kept well informed of the government's envisioned plan for future. Unfortunately, unlike other foreign democratic countries, the concept of vision paper is not in vogue in our country, where every department mandatorily brings about a vision paper laying down the agenda of that financial year with prior accomplishment. In our country, we are still to reach that level where every citizen are well informed as to what our elected representatives are up to. It is the duty of every ministry in governance to inform people of their agenda and their vision to make a progressive and effective society. I request the Law Minister to present the vision paper of his ministry on every Law Day so that we all know as to what the government is proposing to do. Today, the crisis of confidence in government institution has come in the forefront. The deficiency of every institution in tackling the growing and complicated social problems has become a common feature. It's a challenge that law institution also faces similar crisis. Law and order is the ground stone of every democratic society. Every democratic institution needs to meet this challenge. The viability of government institution depends upon their acceptability by the people. When the viability of the system gets into disrepute, the system becomes less and less useful to the community. The challenge would lie in rejuvenating the system by restoring its credibility and people faith in it. Thus, the foremost challenge to the law and legal department today is viability of the system. Citizens have faith in governance only when there is a confidence in the legal system and faith in the wisdom of their elected representative. This is where the public trust doctrine comes in. We must not only appreciate it, but also accept it. Law and order stands on the fulcrum of public trust. Law Day gives us an opportunity to do introspection and to see how far the hopes, aspiration, expectation of the people have been fulfilled and how far we have been able to progress as a socialist, democratic and secular India as envisaged in our constitution. Our country and its system have undergone drastic changes over 6 decades and is still evolving. Today the governance and law and order may not be up to the mark. That does not mean that legal system has collapsed or is fast collapsing. It is my belief that with all the drawbacks and limitations, with shortage of resources and capacity, we still have a time-tested system and we can revive it to its fullest potential. There is no justification to discard the system by giving it a bad name. Legal system in our country has performed a commendable job which does not need any status report. I will wind up by quoting from Webster, "Justice, sir, is the great interest of man on earth. It is the ligament which holds civilized being and civilized nations together. Wherever her temple stands, and so long as it is duly honored, there is a foundation for social security, general happiness, and the improvement and progress of our race." Thank you.
Thank you very much, Shekhar sir. May I now invite our Treasurer, Mr. Rajesh Pathak, to please welcome Honorable the Chief Justice of India with a bouquet of flowers. Since this is the first function of the bar, since we had the Chief Justice of India designate, I request Rituji to please welcome Honorable Justice Thakur with a bouquet of flowers, the Chief Justice of India designate. May I request our Joint Secretary Ashri Saab to please welcome Honorable the Law Minister of India with a bouquet of flowers. And I can request one of our youngest members, Gaganji, to please welcome the Learned Attorney General for India, Rodgi sir, with a bouquet of flowers. It is my privilege to inform you that today the government has designated today as the Constitution Day. But since 70s, Supreme Court Bar Association has been celebrating this day as the Law Day. And I think it is rightly so, because Supreme Court Bar Association, and we have a Law Day charter, it's traditional to read on every Law Day so that we re-educate ourselves. So let me read this Law Day charter which the Supreme Court Bar Association has been rededicating itself to on every Law Day since the 1970s. We hold that law is the common heritage and trust of mankind, that administration of justice is one of the fundamental functions of the state, and that judges and lawyers owe their allegiance by the traditions, training, and tenets of their noble profession to the cause and quest of justice. We believe that the discipline of law is indispensably essential for the authoritative and peaceful resolution of all conflicts, for ensuring the orderly development of society, for maintaining the rule of law, for promoting social justice, for safeguarding liberty, and for protecting basic human rights and fundamental freedoms. We affirm that the independence and impartiality of judiciary and the freedom and independence of legal profession constitute the sheet anchor of social order, individual freedom, and equal justice in our society. We acknowledge the social responsibilities and the professional obligation of law in public interest and public service. We emphasize in particular the need to ensure equal and universal access of the people to the system of justice, especially to the poor, the weak, the deprived, and the downtrodden, the need for legal literacy and legal aid, and the need for social audit and evaluation of laws for scientific, rational and pragmatic law reforms. We pledge and dedicate ourselves on this, the Law Day, to the premises and postulates of this proclamation. We have lots of copies. I'm going to request some of our colleagues to circulate them, and we'll also put it on our website and on the notice board for all of us to see. May I now invite our President, Dave sir, to please give his address. Of judiciary and the freedom and independence of legal profession constitute the sheet anchor of social order, individual freedom and equal justice in our society. We acknowledge the social responsibilities and the professional obligation of law in public interest and public service. We emphasize in particular the need to ensure equal and universal access of the people to the system of justice, especially to the poor, the weak, the deprived and the downtrodden, the need for legal literacy and legal aid, and the need for social audit and evaluation of laws for scientific, rational and pragmatic law reforms. We pledge and dedicate ourselves on this, the Law Day, to the premises and postulates of this proclamation. We have lots of copies. I'm going to request some of our colleagues to circulate them, and we'll also put it on our website and on the notice board for all of us to see. May I now invite our President, Dave sir, to please give his address.
Good evening, everybody. Honorable the Chief Justice of India, Justice Datu, Honorable Law Minister, Honorable Justice Thakur, Chief Justice Designate, Honorable distinguished judges of this court, Mr. Attorney General Mukul Rohtgi, Vice President Shekhar, my esteemed colleague, my colleagues in the Executive Committee, indomitable Ms. Aishwarya Bhati, the Secretary, without whom the SCBA would not have been able to achieve what it has tried to achieve. President of the EOR Association, Shivaji Jadhav, distinguished senior friends, Mr. Surabji, Mr. Rao, Mr. Dipankar Gupta, many other senior distinguished friends, the learned law officers who are always present and supportive of our initiatives, and distinguished members of the bar, ladies and gentlemen. On 17 September 1949, Dr. Ambedkar underscored the importance of the Constitution before the Constituent Assembly in these words. The Constitution is a fundamental document. It is a document which defines the position and power of three organs of the state: the executive, the judiciary and the legislature. It also defines the powers of the executive and powers of the legislature against the citizens, as we have done in our chapter dealing with fundamental rights. In fact, the purpose of a constitution is not merely to create the organs of the state, but to limit their authority. Because if no limitation was imposed upon the authority of the organs, there will be complete tyranny, complete oppression. The legislature may be free to frame any law, the executive may be free to take any decision, and the Supreme Court may be free to give any interpretation of the law. It would result in utter chaos, he said, unquote. A week later, on 25th of November 1949, Dr. Ambedkar expressed serious apprehensions about the success or the failure of the Constitution. And I quote, "Because I feel, however good a Constitution may be, it is sure to turn out bad because those who are called to work it happen to be a bad lot. The factors on which working of those organs of the state depends are the people and the political parties they will set up as their instruments to carry out their wishes and their politics. Who can say how the people of India and their parties will behave?" he questioned. It is therefore futile to pass any judgments upon the Constitution without reference to the part which people and their parties are likely to play. Unquote. This is what he said way back in 1949. Regrettably, a lot of it is prophetic today, as it turns out to be far more realistic when we see the Constitution, the constitutional morality, and the constitutional ethos all around us. Between these profound statements of Ambedkar lies today's India and its constitutional morality. As we all know, the first session of the Constituent Assembly was held on 9th of December 1946 and was attended by 207 extraordinary Indians. The drafting committee under chairmanship of Dr. Bhimrao Ambedkar prepared one of the most outstanding documents, the draft constitution. After spending 166 days over 3 years, this Constituent Assembly comprised of these great men and women approved the draft constitution on November the 26th, 1949. That's the law day's significance. We are here to commemorate this day, November 26th, as one of the high turning points in the birth of a new nation and democracy that we established under it. But it's equally important to remember that the process of evolution of constitution began way back in 1895 when Lokmanya Tilak and N.E. Besant put forward a document titled Constitution of India Bill, also known as the Home Rule Bill, which envisaged freedom of expression and equality before the law. In 1924, Motilal Nehru introduced a resolution outlining procedure for drafting and adopting a constitution for India in the State Legislative Assembly. When Lord Birkhead, then Secretary of State, challenged Indian leaders to produce a constitution which carries behind it a fair measure of general agreement among different sections of the society, the Indian National Congress convened a all-parties conference in 1928 to take up the gauntlet, which appointed a committee under the chairmanship of Motilal Nehru to determine the principles of Constitution of India. Nehru Committee submitted its report on 10th of August 1928, which in effect was the outline of the draft Constitution of India. It was later in 1936-37 that M.N. Roy and Jawaharlal Nehru propounded formation of the Constituent Assembly with widest possible franchise for framing of a constitution, which ultimately the British agreed in 1945 after the Second World War. And the Constituent Assembly obliged us for all times to come with one of the greatest gifts, the Constitution of India, our Gita, our Quran, our Bible, and our Guru Granth Sahib. The nation stands together with all its successes and failures only because of the Constitution of India. But we have huge challenges. I do believe that these challenges, whether erosion of rule of law, denial of justice to tens of millions, poverty, illiteracy, corruption, and intolerance towards women, Dalits, and minorities, can all be successfully resolved with greater adherence and worship of the Constitution and constitutional ethos. Aristotle had once said, and I quote, "The greatest of all means for ensuring the stability of Constitution is the education of citizens in the spirit of Constitution." Celebration of Law Day is an endeavor in that direction, although in a small measure. In the last century, Albert Einstein, the great physicist, put it even more beautifully when he said, and I quote, "The strength of the Constitution lies entirely in the determination of each citizen to defend it. Only if every citizen feels duty bound to do his share in this defense are constitutional rights secured." Unquote. Interestingly, yesterday, November 25th, was the 100th anniversary of theory of relativity propounded by Albert Einstein, which holds the universe together. Constitutional morality is under challenge. Perhaps we have forgotten its importance much less than its meaning. Constitutional morality, according to Grote, the historian, meant paramount reverence for all forms of the Constitution, and he advocated that it required a self-imposed restraint and its articulation, not just amongst the majority, but amongst all classes to establish a government at once free, stable, and peaceable. Ladies and gentlemen, I very respectfully urge that India today needs to follow what Aristotle, Grote, and Einstein wanted: constitutional education of each citizen, coupled with each citizen's oath to be bound to defend Constitution, and utmost reverence of this profound document, the Constitution of India. Thank you very, very much.
Thank you very much, President Sir, for rededicating and reigniting the whole aspect of Constitution, its meaning, importance, drawing parallels with the current times. May I now invite the Attorney General for India, Mr. Mukul Rohtgi, sir, to kindly give his address.
The Chief Justice of India, Chief Justice Designate Justice Thakur, the Law Minister, Mr. Dave, Mr. Shekhar, Aishwarya, judges of the Supreme Court, law officers, doyens of the bar like Mr. Sorabji, Mr. Rao and others, advocates, friends and students. We stand here today to celebrate the vibrancy of the primary document which is known as the Constitution of India. As you are aware, we follow the British model in terms of Parliament, in terms of our judiciary to some extent. But what is important to note is that Britain does not have a written constitution. You have to consider the mammoth task which was placed before Dr. Ambedkar and other members of the drafting committee. All we had was, to some extent or a limited extent, the Government of India Act 1919, 1935, etc. But the mammothnesss of the task can be appreciated by the fact that we drew from the American Constitution, the Irish Constitution, and many others. And this was a task virtually single-handedly carried on by Dr. Ambedkar, a great visionary. And you will be astonished to know that various persons in the Constituent Assembly and the drafting committee were not lawyers. They came from different walks of life. Some were businessmen, some were ICS, some were traders, some were retired persons. They all came together and in a matter of about 3 years produced a document which still holds the field. It may have undergone about 100 amendments. It has moved with the times. It has had the elasticity to move with the times. And that is the beauty of this document. If some people care to read, and I urge everybody to look at the debates before you address a particular argument or a case or a particular provision of the Constitution. And in regard to important articles of the Constitution, the debates will show that there were discussions on every word, on every phrase, and thereafter specific words were chosen by the Constitution. For a country as vast and as huge as India, with different religions, different ethnic groups, people from different walks of life, Dalits, scheduled castes, persons of backward classes, it was very difficult to assimilate everything in one document of hope. It is not like the US, it was not like Britain, that by and large people belong to one religion or two religions and a singular walk of life. To assimilate so many streams into one and bring about a document which still is the uppermost in our minds while we decide cases or while people go about their ordinary lives. The importance is that I would say that the Constitution really set out the path to be followed by a sovereign democratic republic, which is India. And if this path is followed, it will relieve us of a lot of tensions. Stretching the Constitution beyond what it meant at the hands either of the legislature or the judiciary or any other group will lead to problems and will not lead to an orderly situation. I would say that it is something like a code of conduct which is to be followed by every compartment and every group whether the legislature, whether judiciary, whether the executive and the bureaucracy, and most importantly, the citizen. The rights of a citizen in part 3 are balanced vis-a-vis the rights, vis-a-vis the fundamental duties. So the document sets out in sufficiently clear directions as to where a modern India should go. It sets out like a beacon of what we should strive to achieve. And no matter that we have very dissimilar groups, very dissimilar thoughts, but ultimately what will hold this country together as a sovereign democratic republic is only this document and this document alone. When we realize that this is the document which we have to preserve jealously, we may seek to improve it, but let everybody know and let everybody be clear that this is the path which we have to follow. And if you follow this path, there will be orderly growth and orderly progress. It is with these words that I stand here to say that the document must remain uppermost in our minds, and it is the duty of every person to protect this document, like whether it is the Gita or any other religious book, the Quran or the Bible. As Mr. Dave said, this document has the same status as every other religious document or religious book which we have. Thank you.
Thank you very much, Rodki sir. The tempo and the thought is very clear, and taking it a little forward, I would say that the time has come that all Indians should recognize Constitution as their first religion. May I now invite our Honorable Law Minister, Mr. Sadanand Gowda-ji, to please come and give his special address.
Chief Justice of India, Honorable Mr. Justice Dattuji, Honorable Chief Justice Designate Justice Thakurji, President, Vice President, Secretary and members of Supreme Court Bar Association, other invitees and dignitaries, ladies and gentlemen, friends from media. It is my pleasure to be with you on the occasion of Law Day function. We have started debate and deliberations on the floor of the House today with regard to the constitutional obligations and the things which we need to take further steps as far as the constitutional verdict which was given by Dr. Ambedkar. Of course, the debate started and it will continue till tomorrow evening. We hope that some new ideas will emerge on the floor of the House also to see that certain steps need to be taken to suit the present needs of the country. As we all know, November 26, 1949 is a red letter day in the history of our country, the day on which we adopted our Constitution. It is in memory of that day since 1979 we are celebrating Law Day on 26th November every year. The preamble to the Constitution identifies securing social, economical and political justice for all citizens. Our forefathers have allowed us, the people of India, to carry forward the dream of creating a nation ruled neither by historical injustices nor by personal whims of dictators, but by a democracy most vibrant and ever aspiring to uphold the rule of law. Since it is only by adhering to the rule of law we can seek to deliver timely and quality justice as envisaged in the Constitution and reinforce public confidence in the justice administration system. It is befitting that on the Law Day celebrations we rededicate ourselves to the cardinal principle of rule of law. Independence of judiciary and legal profession are the other principles flowing from this very cardinal principle. Rule of law permeates the entire fabric of the Constitution and is the basic feature without stating so. The necessary element of rule of law is that law must not be arbitrary or irrational, and it must satisfy the test of reason. Justice Khanna in ADM Jabalpur case stated that rule of law is antithesis of arbitrariness. The concept of rule of law loses its vitality if instrumentalities of the state are not charged with the duty of discharging their function in a fair and just manner. In a system governed by rule of law, there is nothing like absolute or unbridled power exercisable at the whims and fancies of the respiratories of power, but power exercised only along well-organized and sound justice principles with a view to promoting fairness, inducing transparency, and aiding equity. Access to fair and quick and speedy justice is a constitutional guarantee. Article 14 lays down the principle of non-discrimination by assuring every person of the right to equality before the law and equal protection of laws. Article 21 guarantees that no person will be deprived of their life or personal liberty except in accordance with the procedure established by law. The responsibility to protect these basic rights of the common man has been cast on a judiciary and a legal profession. The peculiarity of legal profession is that what the lawyers do affects not only an individual but the administration of justice, which is the foundation of a civilized society. An advocate is an integral part of the administration of justice. He is an officer of justice and friend of the court. The critical position enjoyed by an advocate, in fact, imposes a responsibility upon him to ensure that justice is made available to all. No wonder the members of this profession are expected to uphold the traditions of profession and serve the society with sincerity and honesty. By virtue of the preeminence which senior counsel enjoy in the profession, they not only carry greater responsibilities, but they also act as a model to the junior members of the profession. Further, in a democratic country like India, judiciary plays a vital role in governing a welfare society as the custodians of fundamental rights and freedom of citizens. Indian courts in the past and today have done a commendable job not only by upholding the rule of law, but also by various other path-breaking initiatives, including public interest litigation and setting up of green courts. Also, we have witnessed that our courts have grown and evolved accordingly to the tremendous tidal changes in the state of affairs of things over a period of time, including the advent of socio-economic revolutions and transformations on the global level. It has thrown up many challenges as well. The huge pendency of cases, challenge to reduce inflow of cases, need to have alternative dispute resolution mechanisms, making the justice accessible to poor and marginalized, identifying and removing the archaic provisions of living laws, adopting structural changes for enhanced accountability and capacity building are some examples. While the government remains committed and has been proactively doing its bit, including by increasing the strength of judges at various levels and developing the infrastructure to enable the courts to function effectively and efficiently, equal onus, if not more, lies on the bar and bench as well. To overcome these challenges, you are aware that the government has already undertaken the National Mission for Justice Delivery and Legal Reforms with the objectives of increasing access to justice and adopting structural changes for enhanced accountability and improving capacities. You may recall our Honorable Prime Minister, Shri Narendra Modi ji, has very recently in his speech on National Legal Service Day emphasized on Sabka Nyay along with Sabka Saath, Sabka Vikas. I therefore feel apt on this momentous occasion to point out various concerns and barriers to access to justice.